number 27, Healy versus EST Downtown. Counsel?
Thank you. May it please the court, my name is Jim Nava from the law offices of John Wallace. I would like to reserve 2 minutes for rebuttal, please.
You may have 2 minutes, sir.
Thank you.
You're welcome.
The issue in this case is really the proper boundaries of Labor Law 240, specifically whether, in this case, a maintenance worker standing on a ladder to remove debris from a rain gutter is entitled to the extraordinary protections of the scaffolding law. At the appellate division level, this issue was addressed in the terms of whether the activity was in the enumerated activity of cleaning. And of course, to make that determination, the court properly referred to the Soto decision and the 4 factors. 2 of the 4, well, the appellate division unanimously found that 2 of the 4 factors favored my position that 240 does not apply to this case, that it's not the type of cleaning as defined in the statute. The court split on the other 2 factors. So I'm going to talk about the factors that the court split on. The first one the court split on was whether this is a routine type of activity. And the Soto talks about the type of activity that takes place on a relatively frequent basis. We have a plaintiff removing a nest from above a doorway. Birds form nests on buildings. In the Soto case itself, the question was about whether dusting a shelf was a routine activity. At least that factor was addressed. Well, dust forms on shelves the way birds build nests on buildings. I mean, the court never addressed whether the plaintiff had ever removed dust from a shelf before, or how frequently did it happen. Rather, the court said that cleaning dust from a shelf is the type of activity that would occur in a retail establishment.
For the question of the routine type of the task, do you look generally to what groundskeepers do, or specifically as to what this particular plaintiff would do?
Well, the court in Soto looked generally to the type of activity that is done in a retail establishment. Again, the 4th Department decision seemed to talk about, well, he never removed a bird's nest before, so that means it's not routine. But we don't know in Soto whether this particular plaintiff ever dusted a shelf before or not. And the court, I think, twice used the phrase, the type of activity.
So to put a point on it, are you saying that as to that factor, the appellate division majority used the wrong legal test?
I think I would agree with the dissent's characterization that they misapplied that factor, they misunderstood it, and they focused on whether he had done it before. And again, some of the arguments on this point raised by counsel and possibly addressed by the majority were the fact that it's a bird's nest, it's not leaves, because as I put in my papers, there were a number of cases where the appellate division consistently held that removing leaves from a gutter or debris from a gutter is not the type of cleaning that's covered by the statute. And the argument was made, well, this wasn't leaves, this was a bird's nest, and that somehow makes it different or non-routine or extraordinary or unusual, and it's not.
So is the question, is it a routine type of task for a groundkeeper to remove birds or pests from gutters?
Yes, I think that's right, because he testified as to what his job was, what his duties were, and they were to maintain the grounds, to keep things clean, and to respond to complaints. And that's what he was doing. He was responding to a complaint. So this was a routine thing for him. He had to climb a ladder.
Well, but that's, I think, what we're trying to get at. Does it matter whether it's routine for him or not, or does it matter whether it's routine for people generally who do this kind of activity?
I think it's routine for him and for people. I mean, I've cleaned gutters. I think everybody knows that things accumulate in gutters, and we're talking about, is this more like a domestic household type of cleaning? Domestic household cleaning frequently includes cleaning gutters. I don't
But
know.
let's do it as a hypothetical. So you have two different cases, and in one case, same job title, two buildings side by side, same building. And in one case, that every week, the task of this person is to go up and clean the gutters. The owner has a gutter fetish, so I want my gutters cleaned all the time. And the other one, maybe the handy person does it once every 9 months. Routine in both or not routine in both?
I think it's routine in both, because I think that gutters accumulate debris, and therefore cleaning gutters on a structure, if you're an owner of a structure, you have to address that. Some people may be more particular, but it's something that recurs over time, and you have to address it, and you clean it out once, you're going to have to clean it out again.
So what's the legal definition of routine? What's the holding that you propose here?
Well, the court in Soto did, the court in Soto said routine means in the sense it is the type of job that occurs on a daily, weekly, or other relatively frequent and recurring basis as part of the ordinary maintenance and care of commercial premises.
So daily or weekly, maybe not every 9 months. That sounds non-routine.
Well, the court says, or other relatively frequent and recurring basis. So if it were, that might make a difference, how frequently it recurs based on this definition. But again, I would focus.
Now you're going back to how frequently the particular plaintiff performed it rather than the job generally, and that's what I'm trying to sort through.
Well, it seems to me that we don't know in Soto how frequently the plaintiff did it, and the court ruled that it was routine in Soto without making that inquiry at all. The court said dust collects on shelves. Dusting shelves is a routine activity if you own a retail establishment. And my point is that if you own a building, you're going to get debris in your gutters.
So Counselor, in your view, cleaning gutters can never be cleaning under the labor law for protective service?
That's a very good
purposes?
question, and I would say, I would disagree with that. You know, you have to apply all these factors, and some gutters may be higher than others, and some gutters, you know, function differently depending on the type of building. There might be, you know, somebody could drop a worker could drop a sledgehammer or heavy equipment in a gutter, and you'd have completely different considerations. It would be a whole different type of activity. You know, the question here is,
So would
standing
the
on a
other
ladder.
factors then come into play to make a determination as to whether it is covered?
I'm
The
sorry,
SOTA
could you
fact-
see?
With the other SOTA factors, for instance, with respect to specialized tools necessary or equipment in order to get the gutters because they're so high, would that help make that decision?
I think that the factors are all related. You know, for example, how high was it? What type of equipment would be necessary? I would agree with that. So I don't think the court should make a ruling that cleaning gutters is never covered.
So counsel, I'm on the screen. Let me ask you a question before you continue. I'm just trying to figure out why you're going down this particular rabbit hole. So if we agree with the appellate division majority below on the two that you also agree and the dissent agrees that are not factors that are satisfied, the SOTO factors satisfied on this fact pattern, but two were, and you're arguing you've started out on one, I assume you're going to get to the second, right? If we disagree with you about sort of the view of these SOTO factors, where does that leave us? Because SOTO does say it's, right, the presence or absence of any one is not necessarily dispositive.
That's right.
You look at the totality. right?
That's right, Your Honor.
Let me just ask you this. How do you understand that sentence? You look at, if viewed in totality, the remaining considerations. Do you take that word considerations to mean the other factors or other considerations?
I understood it to mean the other factors.
Well, why doesn't it say that then?
Well, I don't, well, the court, those were the, those, that wasn't, in Soto, the court looked at those factors. And
Yeah.
if there's other considerations, I guess if the court would be open to hearing other considerations, that would be fine. But it seems to me the way Soto is written, it's those factors. And maybe I'm reading it wrong, but
So then, do you read the appellate division majority as saying, when it says, 2 are in favor of the plaintiff, 2 are not, we're looking at the totality, and we think then that the remaining considerations militate in favor of the plaintiff, you take that to mean that the court thought, given the 2 that militate in favor of the plaintiff, that outweighs the other 2?
I was hoping the court would have explained that, and the court didn't explain that. And it's
The court there, you mean the majority below?
the majority at the appellate
Thank you.
division.
Okay.
And for example, and that sort of brings me to this other point about the elevation. Again, we've got unanimity that 2 factors don't apply. We've got a split decision on the other 2. So that seems to me it's leaning a little bit in my favor just because of that. But let me move
Well,
on.
no, it's 50-50, you're an equipoise. But go ahead.
That's certainly an argument.
Yes.
In other words, it was the factors that in my favor are unanimous and the factors against me are split decision, is what I'm saying, which I
Fair enough.
understand. I'm not saying that's dispositive, of course. But the elevation issue, this was a 5-foot elevation. The majority didn't address the specific elevation.
So just so I'm sorry, over here again, so there's agreement that the elevation was 5 feet?
That was,
There's a factual dispute about whether it was 5 feet.
it was, the only testimony on how the accident happened came from the plaintiff, and he said it was 5 feet. He was on the 5th rung,
Okay,
and
so
they were
the
a foot apart.
dispute then is about whether 5 feet is comparable to household cleaning?
Correct.
Okay.
And Soto, the court ruled that 4 feet was comparable.
Well, that was a 4-foot step stool sort of ladder, but I don't think in Soto there was testimony that he was on the top of that 4-foot stool. And I think instead, the evidence in Soto was that the shelf he was dusting was at 6 feet high, and Mr. Soto was 5'10". It would be a little incongruous to make yourself 10 feet tall to dust a 6-foot shelf.
I noticed that, and I had the same question. And I looked at the briefs to the appellate division, and the defendant's brief said plaintiff testified that he allegedly climbed 4 steps to the top of the ladder. So I agree that it's hard to understand from the decision why, I agree, why would you climb 4 feet to do that? But again, my review of the documents below indicates that the plaintiff testified that he climbed 4 feet. And anyway, I don't want to belabor that because I don't know. But let me point out this. Certainly the dissent felt that 5 feet was comparable to domestic cleaning. 5 months after my case, in a case called Fullbrook, the Fourth Department ruled on this exact issue. A commercial cleaner, 5 feet up, Fourth Department unanimously said that that was comparable to domestic cleaning, and they ruled that 240 did not apply. And I applaud the panel, which included Judge Troutman on that case. So I think that, again, the fact that that's a close question, that it's not overwhelming in one direction, would not support the majority's position that 2-2 should go to the plaintiff.
Thank you, counsel. Counsel?
Thank you.
Good afternoon, Your Honors. May it please the Court. Jonathan Gorski from Dolce Panapino on behalf of the plaintiff respondent, James Healy. I think it's important to start by saying what this case is not. This is not a case involving the routine and frequent cleaning of gutters which occurs annually or semi-annually in the maintenance and care of a commercial or residential property. If that was the case, I would not be standing here before you today. This case would not have made it this far. It's well established that routine and frequently occurring cleaning of gutters is not covered under the labor law. But that's not what we have here. What we have here is different. This is not routine. It's not scheduled gutter cleaning.
So you
Counsel,
don't,
I'm sorry, I'm not even sure, I'm not convinced that this is cleaning at all. Although it seems to be understood at the appellate division and even among counsel here that what we're talking about is some species of cleaning, but this was it was a pest control request. there's certainly a difference between removing a bird's nest and cleaning the leaves out of a gutter. To me, it seems like this is a subspecies of building maintenance or something like that. Am I constrained by the record to view this as a cleaning case?
Your Honor, I respectfully disagree with your position that this does not potentially implicate cleaning. The definition that has been used at appellate courts is the Webster's Dictionary, and it's the removal of dirt or other impurities, extraneous materials. Here we have an extraneous material.
Birds are impurities?
Well, this is the nest itself, Your Honor. The impurity, what's being removed is the nest. The nest is composed of sticks, other materials that they use to bind the nest together. That's what's being removed. That's what's being cleaned from the gutter. Just like cleaning, I mean, I think everyone would agree that cleaning leaves and dirt and other things from a gutter is cleaning.
The
This is
ticket
clean.
that plaintiff got, the work order that was given to him was a pest control work order, wasn't it?
It did say that it was a pest control work order. You are correct, Your Honor.
Do they have a cleaning work order
Your Honor,
that's issued?
I don't know the inner workings. What I do know from the record is that when there's a complaint from a tenant regarding an issue at the property, it comes in a work order. And the work order, how the work is described, is put in by the supervisor that gets the complaint and then gives it to the plaintiff or other workers that are similarly situated as repair and maintenance technicians.
Do you find it of, well, we could talk about how it went to a repair and maintenance technician, but for now, do you find it of any significance that the work order denominated the task as pest control and not cleaning?
I find it of no significance, Your Honor. The work order is certainly not dispositive as to how it's described.
Is the type of work that a groundskeeper do dispositive?
Well, in the Joblin case that was decided by this court some time ago, the court held that a worker's title or the work that a worker generally does is not dispositive. Here we have a maintenance repair technician. He does maintenance. He does do maintenance, ordinary maintenance, cutting the grass, weed whacking, turning over
Answering calls of pests?
turning over. There is no evidence in the record that he's ever responded to a complaint regarding a bird or any other pest. So
he
we
had
don't
to
know.
have responded in the past to this type of complaint?
There's nothing in the record indicating one way or the other. He did testify that he has never, in his 3 years working for First Amherst Development, he never removed a bird's nest from a gutter. There is testimony of that, or I'm sorry, there is evidence of that. There is no evidence as to whether there were any
So
other.
we focus on that which is specific as to him?
Well, no, I think you have to look at it generally and specifically. If you look at it generally, this is not the routine scheduled cleaning of leaves, dirt, water that enters into a gutter through the normal use and operation. This is something that came into the gutter. It's extraneous. It's being removed.
Well,
I've owned my home for 7 years.
Can something be routine and unscheduled?
Can it be routine and unscheduled?
Yeah.
Yeah, I would say that turning over an apartment for him. So a tenant leaves, he goes in, it's not scheduled, it depends upon when the tenant leaves. That's not scheduled. He goes in and turns it over, does some vacuuming, mops the floor. That's routine. That's not scheduled.
Okay, so routine doesn't depend on being scheduled.
Well, if we look at what this court had stated in Soto, the definition of routine depends upon whether it's frequently occurring, whether it happens on a daily, weekly, or some other interval basis. Here we don't have that. We have 3 years of him working as a First Amherst Development maintenance and repair technician. He had never done it. So in the general sense, removing a bird's nest from a gutter is not routine. I've lived at my house for 7 years. I've never removed a bird's nest from a gutter. And it's specific to him, it's non-routine in the sense that he has never done it before. He's worked for First Amherst Development for 3 years. He's never removed a bird's nest from a gutter. So whether we look at it,
I'm sorry, and I take that point, but can I ask you something different?
absolutely.
This test, our Soto cleaning test, right, is somewhat flexible, let's say, right? And what I'd like to get your opinion on is, what's the role of this court in reviewing the appellate division application of that test, since, you know, we've had some algorithms lately before us, and seems to be the opposite. You don't put, you apply this, if you don't have this part, you can look at the other parts. We're not usually, I mean, it's somewhat unusual for us to be in the position, are we, to just reapply this test, and if we get a different answer, that's the way we go?
Well, I think what the question is whether the appellate division properly applied the factors. That's the question to be decided. And if this court finds that the appellate division did properly apply the factors, and based upon the totality of the circumstances, it militates in favor of cleaning, then the court should affirm. That's the court's role in this case, is to determine whether the four SOTO factors were properly applied to the facts of this case. What the defense is trying to do, even though they've backed off of it today, is they're trying to create a categorical exclusion for cleaning of gutters. It's clear, I said it earlier, if you're doing routine cleaning of gutters, it's not covered. This is not routine in that sense. There is no categorical exclusion. That's not how we look at the labor law. That's not how this court has instructed lower courts to look at the labor law. It's not black and white. There are no such things as categorical exclusions. One goes into pile A, one goes into pile B. We need to look at each case on a case-by-case basis, look at what the plaintiff is doing at the time, and decide the case based upon those facts. The best example I can give of that is commercial window cleaning. This court has decided that commercial window cleaning in some contexts is covered. In other contexts, it's not covered. Okay? So the court has decided that essentially the same exact task, water, soap, a squeegee, a sponge, a rag, that's used to clean a commercial window is covered in some contexts and is covered in not. I point the court's attention, I direct the court's attention to the Swiderska case and the Bragi case, almost the exact same circumstances. However, in the Bragi case, Labor Law 240 did not apply because there was not an elevation-related hazard, because the plaintiff was provided with the tools to permit him to stand at the floor level and do the cleaning instead of climbing on top of a desk. In Swiderska...
Okay, so that strikes me as a little bit different, right, than where I thought you were going. So let me ask you this on this. Sometimes window cleaning is covered, sometimes the commercial window cleaning, sometimes it is, sometimes it's not. So you've got regular window cleaning that happens on a commercial building, right? And then you've got a tenant who says, a bird just left some stuff on the window, I can't really see through it, get someone up here to clean it. Which one's covered, which one's not? Same tools used.
Under commercial window cleaning,
No, I'm asking you, you said there's this, we've set out this distinction, so I'm asking you how this hypothetical would work as you understand the distinction that the court has set out.
Sure. We would have to look at the other considerations, which is what the Soto court directs us to do. Look whether there's an elevation differential. Look whether it's routine in nature, either generally or specifically to the plaintiff himself. Look at the tools that are used. There are other considerations that the court uses to differentiate two tasks that are seemingly very similar and in some contexts the same. So you need to look at the other considerations in that case. If it's at ground level and someone is cleaning a storefront window at ground level and can do it based upon the height and decides to stand on top of decides to use a step stool, well, that's not covered. There's no elevation differential, no elevator or elevation-related hazard. On the other hand, if it's on the second floor or the third floor and it has a significant elevation-related hazard, that could be covered. We need to look at each case factor.
I know, but that wasn't my hypothetical. We're going to assume that there's an elevation component in my hypothetical, that you're up on the 47th floor, okay, and you're outside and you're doing it that way. Which one's covered, which one's not?
Well,
You mean it matters whether or not the person who came up and regularly cleans the windows also came up to clean the stuff that the bird has left on the window?
I think that would matter under the court's direction in Soto as to whether it's routine, something that happens daily, weekly, or on some other recurring basis, and whether it's specific to the worker himself or generally. So we'd have to take a look at the other considerations. One being, as Your Honor has alluded to, whether this specific worker normally does this work. whether this is his type of work that he does on a daily, weekly, or other recurring basis.
Let me just ask you one more thing before your time's already up, but with the chief's indulgence. The appellate division expressly said it wasn't deciding the claim about repair, right, under 241. If we disagree with you, right, if we reverse, what happens to that? Is that still live or no?
Yes, we fully briefed that at the appellate division on repair and alteration. So that is in the record. That was before the appellate division. So our position would be that if the court does decide against us on cleaning, the court can look at the record and make a determination on the law based upon the facts. There is no factual dispute here. This court sits in the position not of the trier of fact, but on the question of law. And here, since there is no dispute in the record over what the plaintiff was doing, the court can determine that this is covered work under a different enumerated activity, that being either repair or alteration.
Thank you.
Thank you, counsel.
Thank you.
Counsel, your rebuttal?
Thank you, Your Honor. Quickly, on whether it's a repair or not, that may be the one question of fact that's in here, is that the plaintiff said that he was intended to patch the holes as part of his job, and his supervisor said, no, he wasn't. So that is a question of fact, and that may be relevant to whether it's a repair or not. That's been briefed in detail. I cited the Azad case, which said patching holes in gutters that are functional is not a repair, it's component replacement. I mean, that's a whole other argument. I don't think I have time
So
to.
then, counsel, does that mean, I'm on the screen, does that mean that if the court were to agree that this doesn't fall under cleaning, that we have to send it back to the appellate division?
I don't think so. My understanding is,
Or if there's a factual dispute, how are we going to resolve that?
well, if the court finds that it's not a repair, then that's the end of it. If the court finds that patching the holes is a repair, then we need to have a trial on that issue. My position is it's not a repair, and I rely on the Azad case in my arguments. It was a functional gutter. I don't concede that this is cleaning. I'm here talking about cleaning because the Fourth Department picked up on that. That was one of many arguments that we made in our papers. The trial court did not address cleaning, and then we went to the appellate division, and the whole decision is based on SOTO. So I agree that putting your hand in a hole and pulling something out isn't necessarily what everybody's idea of
Do
cleaning
you
is.
agree, counsel, with your opposing counsel's description of our role in reviewing the application of SOTO by the appellate division?
Here's my understanding, as maybe the least experienced appellate attorney in the room, because I did look at this. My understanding is that this court reviews this decision on a de novo basis. And, whatever arguments are before the court may address. I raised other arguments. I listened to people talk about non-defective ladders all afternoon, and we have a non-defective ladder in this case, and I think the court ought to reverse the appellate division because there's no fault, there's no liability because there's no statutory violation. Plaintiff said the ladder was fine, it was proper, it was non-defective, it performed as it should perform. It was placed properly on a flat, level, dry concrete surface. A bird startled him, he lost his balance and fell. And that was not, the ladder was not there to prevent a bird from startling him. The ladder performed properly, it was not defective, so there was no violation, and there should be no liability. And I've raised other arguments. But that's my understanding, is that this court would review all these issues de novo.
Thank you, counsel.